Hi, this is Gracia at Rue Ziffra, and today we are going to be talking about frequently asked questions, mostly questions that we get from our clients and folks that are interested in applying for Social Security disability benefits. We have a group of like 7 questions, I think it is, and I'm going to answer them in turn, with the first one being, what should you do when you are denied your Social Security disability benefits? Well, the first thing that you have to know is that after you apply for your benefits, there's a certain number of days, a timetable, that you have to observe before you actually lose the right to continue forward in the process. When you are denied your Social Security benefits, you have 60 days to appeal and go to the next step. In the state of Florida, after your initial application is denied, you would move to what is called a request for reconsideration. It's your first appeal. And you only have 60 days from the date of your denial, original denial, to go into the request for reconsideration. Now, what happens if you are denied on reconsideration also? Well, step 2 will be to request a hearing. This is basically your date in court, and you have only 60 days again. So again, from the date of your denial, from your request for reconsideration, you have 60 days to go to a request for hearing or to request a hearing. What happens if you go to a hearing and you receive an unfavorable decision? Well, the guidelines continue to be basically the same, 60 days to go to the next step. And that would be to the Administrative Appeals Council, the Social Security Appeals Council. If you basically go over any of these timelines, you may lose the right to continue with the process. After you're denied the Appeals Council, then it's Federal District Court, and all the way up to the United States Supreme Court. Administratively, again, 60 days. This is how long you have to go forward for an appeal. I would absolutely recommend that you get an attorney that is knowledgeable in Social Security. There's many attorneys that do Social Security almost like as a side business. In our office, I am board certified in Social Security disability benefits. It's one of the things that I do. I have an associate that is a certified disability representative with Social Security. So believe me, we are very knowledgeable in what we do. And certainly you should take advantage of our knowledge and our experience to help you with the process. You should not do it alone. Second question, are Social Security disability benefits taxable? Yes, they are, but it's going to be depending on your income. You're a single individual. If half of that particular income that you have and other income exceeds $25,000, they may actually tax you. $34,000, depending on the other income, you may be taxed. So that question is very specific on the individual, but generally the answer is going to be yes. Now, for many people, the answer is also no. But being that the question is, are Social Security benefits taxable? Yes, they can be taxable. Third question. Can Social Security disability benefits be garnished? The answer is yes, but by a very limited number of creditors. The federal government, for example, can garnish your benefits. An unpaid student loan, debt to the Internal Revenue Service. Those are 2 good examples and very common examples of one instance that Social Security benefits are garnished. Now, I can tell that almost universally, child support debt most likely can be garnished in Social Security disability benefits. Can a private creditor, like a credit card, go after your Social Security benefits? No. Okay? So, depending on the creditor, normally governmental actors can go after those benefits. Private creditors, mostly, the answer is no. By the way, we are addressing Social Security disability benefits. It's not SSI, Supplemental Security Income, which mostly cannot be garnished by anyone. The next question. What Social Security disability benefits do I qualify for? Well, that would depend. Obviously, if you are applying for disability, meaning that you believe that you have become disabled, disability benefits are available to you. If you are going to be now retiring, you will get, obviously, retirement benefits. But what happens, for example, if you have a significant other, a spouse who has passed? Well, you may be able to get the record of that spouse if it's a higher record, meaning a higher income record that you can actually then receive a benefit from with a couple of specific requirements. If it's going to be a spouse, individuals have to be married for 10 years, be at least 50 years of age and disabled to get the benefit, as long as the spouse that you want the benefit from was receiving Social Security benefits. Okay? What happens if you're not disabled, but you have been married for a long time, and you are now 60 years of age? Well, you don't have to be disabled then. At 60, if you have the other requirements of being married for the 10 years, and the individual was a recipient of Social Security, in other words, had the benefit, you can then go after that higher record. Social Security will go for the higher record. They're not going to combine records. Okay? They always go for the higher record. And what happens if you have a much higher record? Well, Social Security will say, well, you have a much higher record. But point is, like, that's a benefit that you can try to get. Also, minors get parts of benefits when, for example, a parent is disabled. Those are called auxiliary benefits. It's something that we see a lot, especially for folks that have minor children. Now, these are, again, Social Security disability benefits, not SSI. You're not entitled to get auxiliary benefits for SSI, meaning for your children, okay? So those are the normal benefits, types of benefits that you can get under Social Security. There are more, but not necessarily relevant to what we do here in the office as it relates to Social Security disability. How are Social Security disability benefits calculated? Well, quite simple. From your what is called your primary insurance amount, what you have paid into the system. The more you pay into the system, the higher the benefit. And that's the way basically they're calculated. They look at years past. They have a particular formula. I'm not going to go into it. But in the end, what you have paid in is going to be the bulk, the base of what you're entitled to get in Social Security benefits. What is the maximum Social Security disability benefit? Well, the maximum Social Security benefit, in essence, is your full retirement benefit, okay? Social Security benefits turn into full retirement benefits. Frankly, that's what Social Security disability is. It's simply retiring early as a result of the disability, and you basically get your full retirement benefit early. So if you basically retire at, if you are disabled at 40, they're going to look at your full retirement benefit. It could be when you're supposed to go at 66, which is right now $2,861. You're also entitled to get Medicare early. See, Medicare normally is applied to folks that reach the age of 65. But if you are disabled at 55, 24 months after you're found to be disabled, you get Medicare also. And then that full retirement benefit, whatever you were going to get, the maximum, again, normally $2,861. For those that want to know, well, what happens if I continue to work? And this is obviously not disability, but on retirement at 70, now it's $3,770. If you choose to do your early retirement at 62, you're talking about $2,209. Notice quite the steep difference between one and the other. It goes without saying that as long as you can work, perhaps you want to work the longer you can because the benefit can be considerably higher. And when does Social Security disability change into retirement? Well, in your full retirement age. At a particular point, your disability simply will switch into retirement. You are not going to get more money. It doesn't work like that. Your disability simply switches from disability to retirement. Okay? By that time, obviously, you will be entitled to get Medicare. One question that we get also a lot is, do I really need a lawyer to go through my Social Security disability process? Technically, as a matter of law, no, you do not. You can file your application. You can go through the entire process, administrative process certainly, not federal court, but administrative process without an attorney. I can tell you that the numbers do not lie, and the numbers significantly, folks, favor those that have an attorney. When you have to go to a hearing, which is your day in court, as I said before, you are going to be expected to cross-examine experts, a vocational expert, a medical expert. You're going to be expected to make arguments, legal arguments, that if you do not make, may very well be waived. Get an attorney. So although, yeah, you do not need it, just like you don't need a lawyer to go in to court and try a case, remember, only a fool has himself or herself for a client. It's an old saying that rings true, because frankly, if this is not something that you do you shouldn't be doing it, and make your day count. Again, at Rue Ziffra, one of the things that I do is Social Security Disability. I am one of only 10 board certified attorneys here in the state of Florida, nationally board certified. And the only thing that means is the commitment. I commit to the area of Social Security Disability. So if you ever have any questions, 386-788-7700. My email is lgracia@rueziffra.com. Feel free to email me or to call, and I'll be more than glad to answer the questions as best as I can, and to help you out and to represent you should you need it. Until next time, take care.